Welcome, everyone. I'm going to go ahead and get us started. My name is Renee Dancer, and I have the pleasure of moderating this panel today. You'll see the panel's the title of the session is quite long. The role of court administrators and clerks in developing effective partnerships to close the access to justice gap. I'm going to allow the panelists to introduce themselves because I think they do themselves much more justice than I am capable of doing. But first, I just wanted to do a couple housekeeping items. This is an interactive discussion. It's designed to be an interactive discussion. So you'll see that we're going to provide a bunch of information. I'm going to be asking a bunch of questions of the panelists. But the goal is for you all to engage in the discussion as well. So you should consider every question to be a question to the audience in addition to the panelists. We're really hoping to exchange ideas in this session. And you'll find that usually if I am moderating a session, that is how I like to do it. So I think we all learn best from each other. The goal here today is, I think we all are aware at this point that the Conference of Chief Justices and the Conference of State Court Administrators together resolved to provide 100% access. And I think that is a really lofty goal, and I think we can all agree that that's quite a lofty goal. The point of that, though, is that it does really start at the trial court level. That's where we start providing access. And so it's great to get that leadership and direction from our highest courts, but now we need to figure out how are we going to accomplish that. So our goal today is to really start talking through that and what that means. So our hope today is really to understand what the role of trial court leadership is, including not only just the courts, but also the executive branch and the clerk's office. As well as how to take that leadership and work with the community partners to collaborate and really provide 100% access to justice. So our goals today are really twofold. To first discuss what the meaning of the language in that resolution is, because some of it is, it's a little high level. So we first want to kind of break that down. And then we hope to really talk about how to create those partnerships and collaborate together and what that looks like on the trial court level. So let me first give a brief introduction of really how I know our panelists, and then I'm going to allow them to introduce themselves to you and really brag a little bit. I'm hopeful. I know at least one person on this panel is not really a bragger, so I might have to brag on her behalf. Erica Woodford is the elected clerk of courts in Bibb County, Georgia. So she's going to give you the perspective from the clerk's office. Catherine Alternator is the director of the Self-Represented Litigation Network. One of my roles on the board of directors of NACM has really been to be the liaison between the NACM board and the NACM membership and the Self-Represented Litigation Network, which has really been very self-serving. I've really enjoyed having the opportunity to engage in that community, and it's really given me the opportunity to work in the access to justice field probably a lot more than I would have otherwise. So that has really been a positive experience, and so that's how I know Catherine. Thank you, Catherine, for really allowing me to interject myself in all that you do. And then the final panelist that you'll see here is Amy Ross. Amy Ross is an administrator in the family court here in Pittsburgh. And I think if you were listening to my riveting speech yesterday during the business lunch, you'll know that my former job was here in Pittsburgh. And so Amy and I worked very closely together, and one of the projects we worked on in the family court was facilitating access to justice for self-represented litigants. So she was quite integral in that process, and while I left, she continued and does continue today. So after those brief remarks, I'm going to allow each panelist to kind of talk about themselves and how they fit into the whole access to justice scheme.
I will not sing for you. Good morning. Like Renee said, I'm Erica Woodford. I'm the clerk of Superior Court in Bibb County, Georgia, and I am so happy to be here this morning. To tell you a little bit about myself, I've been an attorney since 2000, so this is my 16th year. This is my 4th year as Clerk of Superior Court in Bibb. I'm finishing my 1st term. My 2nd term will start in January, running unopposed this year. For all of those of you who are elected, that's the best way to run a race, is to run unopposed. But prior to being clerk, I served the citizens of Macon and Bibb County as a civil court judge and magistrate in Bibb Civil and Magistrate Court for 4 years. I also operated my own law practice for 8 years. In my practice, I handled indigent criminal defense. I was a contract attorney in juvenile court and handled juvenile matters. And I also did pro bono, low bono family law type cases. So the overarching theme of my work in the legal field is a commitment to service of others. And I think that if you're in this field, you should be willing to set yourself aside as much as you can so that you can serve others. The tagline for the clerk's office is service, commitment, and access to justice. And that's my philosophy. I believe that we all should have access to justice regardless of our race, religion, our socioeconomic background, our age. So, good morning.
My name is Catherine Alternator. And yes, it sounds like the car part, just doesn't spell like it. And maybe one day I'll be brave like you and run for office and say, start your engines. Feeling stuck, vote for Alternator. But, as you all can tell from the back of my not elegant laptop that doesn't get stolen or lost anymore, I spent a good bit of my life in Alaska. And I was originally a legal aid lawyer in Alaska, and then in 2001 I went to the Alaska court system and started their family law self-help center. If you take Alaska and superimpose it on the lower 48, it goes from one end of the United States to the other, all the way out to the end of the Aleutian chain. So geography was a really significant issue for us. And so we started a remote services self-help phone and internet in 2001 and provided comprehensive help that was targeted towards contested cases. And the design approach for that was really finding out what our customers needed, and the Alaska court system calls the litigants customers, and their clerk's office is called the Customer Service Department. And so we found out what our customers needed and how they best got it. And tried to design our services around that. And then in 2006, I went off to private practice as an unbundled attorney. I'd worked very hard to help bring unbundling to Alaska and integrate it into our delivery system. But I felt that if I didn't go out and try to run a business as an unbundled attorney so I could look at private attorneys in the eye and say, yes, you can make a living doing this, I was never going to be very legitimate in promoting this model. And was able to keep the lights on and actually make a decent profit doing unbundling. And then and during this whole period, the thing that sustained me in our state was my involvement with the Self-Represented Litigation Network. I think it was the first month on the job I met John Grecian, who is here in the room, one of the pillars of our network, and along with Bonnie Huff from the California courts, many of you might know, Glenn Rodden from Legal Services, and of course Richard Zorza, who just tirelessly has produced so much content and so many resources and traveled the country to help us think of a new way of doing business with self-represented litigants. When Richard needed to unfortunately take an early retirement a couple of years ago, they reached out to me and asked me if I'd like the job. And of course, it's a dream job. My job is to talk to innovators and leaders around the country to connect. A friend of mine said, well, you're sort of like the Yenta of access to justice. I'm just supposed to connect people who have great ideas and encourage them and provide resources. So it's just terrific. Renee has been an amazing member of our organization and our network, and I hope, I'll talk a little more about our network later, and I hope all of you will see a place for yourselves in that community because we need your ideas.
Good morning. My name's Amy Ross. I am the only non-attorney on the panel. My background is in psychology and mental health. And I actually have been working for the family court here in Pittsburgh since 1998. And I started out in the child support section, establishing child support orders for many years, and then moved into the enforcement section, dealing with clients who were delinquent on their support or who had warrants out for their arrest. And then I moved into our court's custody department, where we have an alternative dispute resolution program. And I did that for many years, and now I have kind of moved up into management, where my role at the family division is really to oversee our court operations for our custody clients. Most of our self-represented litigants in the family division are accessing our courthouse to deal with issues of child custody. Many of them don't have the resources to afford an attorney, and if they can afford an attorney, it's usually a limited appearance, maybe to help them with a filing, maybe to show up at a motion hearing or something like that, or one court appearance, but they simply cannot afford to sustain that in the midst of litigating their divorce, their property, all of those things. And I've really found in my time that so much of the family court is not really legally driven. There's a lot of, from working with clients these 18 years, a lot of failure for them to really understand from us what the system is, to get somebody to listen to them, to get somebody who will help them, to get somebody who will support them and navigate them through this process. They're very intimidated by the process. The process is often described to me as a maze. They're not sure how to enter it. They're not sure how to get out of it. And it's very long for them, and it's very expensive for them. And they often don't see courts as a supportive resource, but more as kind of an intimidating factor. And so I work really hard to educate our clients and to support our clients and to develop policies and procedures and systems that can understand and have empathy for what they are going through, so that we can be more compassionate.
Great, thank you all. I started talking about housekeeping and then went off onto a tangent, so let me actually tell you what I meant to say when I started talking about housekeeping. This will be an interactive discussion, but we are live streaming and recording this session. It's very exciting. You're on the internet right now. So in order to hear your questions out on the World Wide Web, we need you to use the microphone. So just raise your hand, and I'm happy to bring a microphone around. Please don't let that spoil your desire to ask a question or to give a comment or an experience that you've had in your own jurisdictions. Before we get started in really taking and analyzing the resolution, I wanted to give Catherine the opportunity to kind of summarize a little bit of research that has informed a lot of our presentation today. Rebecca Sandifer is a researcher who has done a lot of work in the area specifically that we'll talk about today regarding what people believe actually are their legal problems and where they believe they don't have legal problems when they might. So I'm not the expert on this research, and Catherine is much more than I am, so I'm going to stop talking and let her take it from here. I'll cue up your slides.
And I'm podium dependent, so. Thank you, Renee. And before I begin, I just have to say I am not an expert on Rebecca's research either. It's really extraordinary and groundbreaking. If you have not had the opportunity to look at her research after this session, I'm hoping I will have inspired you to do so. Rebecca is a professor at the University of University of Illinois at Champaign-Urbana, and also a fellow at the American Bar Foundation, and leads their Access to Justice initiative and research, and has done an extraordinary amount of research about people's needs, also the role of non-lawyers. She and Tom Clark from the National Center are heading up the evaluation of the non-lawyer part of this equation. So I think, she is somebody that is, and hopefully I'm going to demonstrate how she is somebody who gives us a lot of information and food for thought as we think of how to go forward. But before I talk about Rebecca, I am going to talk a little bit, just a little bit more about the Self-Represented Litigation Network. And, we are a network of lawyers, judges, clerks, administrators, technologists, librarians, really, including social service providers, really anybody who touches the justice system, civil justice system, who is interested in reform and innovations to make this a more accessible and consumer respondent system, as well as just efficient and effective delivery of justice. This is a map of our membership, and I'm hoping you think about getting on this map. But you can see we have some activity in all states. To really reach 100% access to justice, we need innovators in every county in America. And so that's really, I think, our challenge as a community who are interested in reform and realignment to bring 100% access to think about those ideas. If you're interested, our website, SRLN.org, has a Get Involved link, and if you click on that, you can request to join our working groups or sign up for a newsletter. We are about to launch a self-help services working group that I think is probably really a good fit for many of you. It is not going to be limited to self-help centers, but also anybody who's thinking about developing self-help services and how those fit in. It will be chaired by, we're currently in formation, and it will be chaired by Mary Jane Ciccarello from Utah, who is the director of their self-help center, and a really great thinker on innovations, and Utah has done a really great work of how to bring their clerk's office and self-help services together. So that's my little pitch. If you like this conversation, please continue. Is there a question? No, okay, sorry. Please continue the conversation by joining. Okay, so Rebecca's research. In 2013, she released a report that looked at, that was the result of interviews that she had done in what is called Middle City, a Midwestern city that has average attributes to most American cities. And they did a little over 600, I think they did 663 face-to-face interviews in households that had been identified. It was they made sure they stretched over the income arc, but it was a random selection from the different stratifications of households, and it was a face-to-face sit-down for about 60 to 90 minutes, talking to people, not about what their legal problems were, but what situations they had encountered. And what Rebecca found right off the bat is that when you ask people what they have as legal problems, and as you're going to hear as I summarize this research, they don't really have very many legal problems. They can't identify the challenges that they face in life as legal problems. However, this situations you may have experienced, we see in this graph that we have, and for those in the back, I'll just read off, and for those on the World Wide Web. Employment, reading from the left over, employment, rental housing, owned housing, money, debt, insurance, benefits, education, relationship breakdown, post-breakdown, personal injury, and clinical negligence. One of the things that really strikes me when we let data help us understand our consumer is that when we're delivering services on the front line every day, right, you're just taking in and overwhelmed by what comes through the door. And so your personal experience is what you think people experience. And it could be, when we're thinking about designing 100% access, we have to think about really what the consumer is experiencing. And just sort of a side story, I think, that captures this. One of my kids, when she was in 5th grade, it was a very rambunctious 5th grade, and the teacher was completely overwhelmed by these kids. And so one day what she decided to do is she had these little yellow cards, and she was going to hand them out to each of the kids that really acted up. As soon as they acted up, they got a card. So she could identify, because she was just feeling completely overwhelmed every day. Well, it turned out there were about 3 rambunctious boys in that class, is what there were. And the other 20 kids were not disruptive. And so once she could identify really where the nail was sticking up, what was actually going on, she could then bring in other resources to help support how she addressed those 3 students, and help so she could get back on track with her lesson plan and so on and so forth. I think we face that often as frontline providers. It's that chaos that comes through the door. And it's whoever sort of the loudest complainant gets the attention. And we also, based on our caseloads, we can notice that some of these situations you experience are not even court problems, although some are. And so as we design 100% systems, we want to think about that. She then looked at what is the impact. How did people talk about the impact on their lives to these situations, which again, only 6% of the situations were identified as legal. And the impact we can see beside that, sometimes verbal, physical assaults, damage to their relationships, loss of confidence, fear, loss of income, and the most significant, damage to health. So when we talk about our communities and the stability and health of our communities, the work you all are doing is so significant to really helping people live their daily lives. And again, our solutions need to bring in helpers that can address these. She asked people how they responded to these situations they faced. And the largest part of the pie chart here is do nothing. So the vast majority of people really do nothing about their legal problems. Or I'm sorry, the 16% is do nothing. Self-help is the largest one. So the vast majority are self-help. And what self-help means, I think later on, Renee is going to give us an example of what self-help really means. There are many states are looking to build a portal. I don't know if any of you are in those states. And sometimes I like to say, well, in some ways we have a portal, it's called Google. And we have to be really mindful of how we fit into that. We also have help from family and friends, and help from advisors or representatives. Very rarely do people want to go to a lawyer. And the driving reason is they just don't see they don't identify it as legal, and there's no need for advice. This is a personal problem that they can figure out. It's an act of God. It's just bad luck. It wouldn't make any difference. And we often think that people don't go to lawyers because it simply costs too much, although the consumers tell us that's not the case. And then a few don't know where to go. So again, these are sort of the explanations that people have of the situations that they face. Bad luck, it's some kind of moral failing on their part, it's just private, something they need to work out with their family, part of God's plan, and a narrow band for legal, social, bureaucratic problem. 9% are legal, according to lay people. 56% are just bad luck. Of the respondents, only 16% of the time did they consider talking to a lawyer. But those that considered talking to a lawyer, but those who considered the problem legal thought about talking to a lawyer 39% of the time, which is still incredibly low. And people just don't think it's worth it. So what does that mean for us? And I think this is where Rebecca's research can really help us to internalize and to talk to our stakeholders about helping people identify they have a legal problem and legal solutions. And I think as Amy was talking about, a lot of times when we talk about legal solutions, it's not just a lawyer, it's legal help. And I think that's where our self-help innovations, a lot of our social service providers come in. Legal help is a continuum of services that we're going to talk a lot more about. And then we also need to match the services to need. Rebecca did another earlier study in 2011 that looked at each of the states and tried to understand a little more about what we knew at that time about the legal gaps, so to speak. And one of I think the big takeaways for me from that research is we really didn't understand, and she noted it, we have a very fragmented system, and we really don't understand what people need. Who are the consumers? Again, that loud, noisy kid in the class is dominating our perception of what's going on. And we don't have a good sense of what's going on in our communities because we have all these fragmented providers and everybody kind of moves their own agenda. And so it's very difficult to create an integrated system. And I'm now just going to very quickly give you a preview of some things that I think will begin to help us as we move forward from the inspiration of the Chief's Resolution 5 and the Justice for All project that the National Center is leading of really helping jurisdictions build 100% ecosystems and continuums. My organization is investing quite a bit of energy in mapping, we'll be able to provide to all of you these maps of various demographic and other attributes that might help people better understand who they're serving and who the partners are that you might bring in. So here is a map showing the density of children. These maps go down to the census tract, to the county level, and in many cases down to the census tract level. So for planning purposes, okay, that's where the kids are, but we know that the 4D funding from child support gives us a huge funding stream for innovations and services. If you're I would submit that if you're a court in one of these dark, highly kid-dense areas, this helps you think, wow, 4D funding might be a priority area for me to look into in terms of innovations and getting some funding to fuel reform in my court and in my community. Another example here, we're looking at the seniors across the country. In many jurisdictions, seniors are entitled to access to senior hotlines, legal hotlines under Title IIIB funding. They could become great partners to the court. So every time you have a litigant who is 60 or older, they could be getting legal information from your senior hotline if you collaborate with that senior hotline and get them your information. So now you've just brought in a whole nother resource to help you manage your folks. Here's a map of veterans. Again, highly dense veteran areas. They're going to be good veteran support networks. And again, you might look to veterans organizations to provide part of that legal help so that you're not carrying the whole burden. Here's another example, and we have a whole range, but I'm just trying to give you a taste for how data can really help us understand now who we're serving. This is vehicle ownership, and the red areas are the lowest vehicle ownership. I think it's 0 to 5% or something of the population. It's pretty significant. And so when we talk about delivery systems, if you're in one of these low vehicle ownership areas, we have to know what's going on with public transportation, or do we want to provide resources in the community locally, partnering with libraries, partnering with social service providers. Getting to a court turns out to be a really big deal in these communities. And so what are our strategies around that? And so I think together, Rebecca's research and really her research inspired me to start looking at trying to use data to understand and whole cloth down to the county level who we're serving. Together, these things can really help us put together 100%. Thank you.
So that was pretty interesting. Does anyone have any questions before we move on, or comments before we move on from Rebecca's research specifically? We can incorporate that research throughout the presentation. I think you might not see just yet how that incorporates, but I think you will as we move forward. So without not seeing any hands at all, we'll move on. So I want to confess something that, first of all, the computer has stopped connecting to the projector. So let me tell you that, and subtly ask for Wes's assistance. The other thing I want to tell you is I'm using a new presentation media, so I'm trying a lot of new things today, and so it might be a little choppy, and I apologize for that, but hopefully it'll all work out. First, we're going to get this fixed, though. I'm supposed to be talking in this microphone, but I don't have much to say just yet. Oh, yes, we have a question. Great. Thank you. We have a woman saving the day today.
One of the hesitations I hear about self-represented litigants is that there's a lot of fear, I think, on the part of attorneys that they are losing business. And so I think that research is really interesting, that it could, in fact, drive business in terms of helping people recognize that they need legal assistance. Have you found that to be true, or has there been research on that question specifically?
Is this on? Yes. Yeah, no, that's a great question. And I can speak specifically to the jurisdiction in which I worked, that as we developed the unbundled piece and trained our self-help staff to help talk through people why a lawyer would make a difference, we saw a significant increase in the amount of legal advice being sought within the community. And anybody that's on that unbundled list turns clients away. Like, they can't take the clients fast enough that are calling. But they don't call for the whole thing. The self-help staff and the court staff have gotten very good at saying, this is all kind of, fill out the form, blah, 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 blah. But this is legal advice, and this is why you should go to an attorney. This is the impact it will have on your life if you don't. We also have heard from California that they think that the vast majority of files, really do get some legal help in the background. So there's ample opportunity. I think it's just that legal services are being delivered in a different way than the give me $10,000 and I'll take over your life.
Thank you. Thank you for that interjection. That was very helpful to me. Okay, so now we're going to start talking about the resolution. And the first question, I think, for the audience, oh, wait, let me show you. Here is the resolution. The first question for the audience is and for the panelists and then also to the audience is actually, I'd like to understand, what 100% access really means to you as personally, as well as what you think it might mean to the public.
Well, for me, and I like to stand up, so I sit down all day, every day, pretty much. But what 100% access to me means that regardless of whatever your circumstance is, you have the right and the access to court, so to the system. You can get your matter heard before a court without having to jump through 50 million hoops. So, and also wraparound services. That's a term that we like to hear, especially in Macon. We talk about wraparound services. So from the start to the finish and even beyond that case, there are some services that will help you with your matter.
Amy, did you want to talk?
I agree. I mean, with much of what Erica said. I think that a significant barrier that I see in family division cases are fees. There are some fees, some filing fees that are difficult for folks. It's also in family cases, I think, they might access the court thinking that that's where they want to be or need to be. But if court staff takes some time to educate them and to give them information and resources, they may decide that that's not the appropriate forum for where they are. In family cases, a lot of people come in thinking this is what they want, and then when they get information that they don't have that isn't out there in the community, or maybe there's misinformation, they really maybe make a different decision or go down a different path. So I think, too, courts need to, while the access needs to be there, we also need to be responsible to say to people, yes, you can do this. We're not going to prevent you from doing this. That's your due process right. But let me explain to you these other options and resources, and let me explain to you what doing this might mean for you. So particularly in cases where there might be things going on within the family, they may not be ready. They may think they don't need to serve the other party won't know because they're not ready to tell them what's going on, or they're not ready to tell their kids. And so they think that it can exist in a vacuum. They don't understand the concept of service, for instance. They may not know where that person is. So I think it's very important. I actually see in Allegheny County, we say, in my department, we get a lot of filings, and we tell the clerks, you have to take a ham sandwich because you can't turn people away. They have the right to access the court. But I think the flip side of that needs to be, we need to explain to them, this may be a ham sandwich. And so that they have information. I think we assume that everybody comes in with those papers filled out, understanding what that means, and really a lot of them do not. And when they have that information, they may make a different choice.
Dexter has a comment. So, Dexter, thank you for offering a comment, and let me just make this an example. We want to hear from the audience what you think 100% access is.
Well, one of the issues I see with the 100% access is that we tend to lean towards trial courts and state courts. However, the precursors actually happen at limited jurisdiction courts. By the time you get it at the family court and the other levels, they've had contact with our courts, whether it's a misdemeanor DUI, order of protection, things like that. And so when you talk about wrapping around the services, we have to make sure that the limited jurisdictions and municipalities and limited jurisdiction courts and counties are part of the conversations. Because we have that initial contact, and it also creates that initial fear, because we don't always know what's going on in general jurisdiction courts, and so we don't give out good information, and we help perpetuate the fear and notions of what's going on, what's going to happen with me in this system. So I just want to say that we got to begin to work together internally as well as externally.
Thank you, Dexter. Anyone else want to offer? Yes, John. Thank you.
Just the point that it's not enough to get into a courthouse or to be able to file a case. People need to be able to know that they will get an outcome in their case that reflects the law and the facts that apply to that case. And so the system needs to make sure that they get fair handling when they come into a court. And as you say, that they also know the other options for getting their case resolved. And as we spend more time on this, we realize that there are lots of barriers based on, I think, misguided notions of judicial ethics that judges feel they are prevented from investigating or looking behind the papers in a case to see what is the just result in that case.
And while Renee makes her way around the room to the other side, I just wanted to interject something. I know Amy mentioned that their court, they may advise the clerk's office to take the ham sandwich, but I have a slightly different perspective on that. As the official record keeper, I'm bound by the law, I'm bound by the statutes that create our office. So if the statute says that I can only accept this type of document, then I will reject the ham sandwich. But with that rejection, I will also give out information. So I might say, no, Dexter, we cannot take your ham sandwich. However, this is what we can take. We have these free forms right here. You need to fill this out, get it notarized, and bring it back. And so a large part of what we do to effectuate justice and to facilitate access to justice is that we have to provide that information, because we can't provide legal advice, but we can provide information. And just out of curiosity, how many clerks of court do we have here? And if you're not the clerk of court, you work in the clerks of court office.
Can we be
Okay. Previous. Very good.
Norman, and then we have another comment in the back.
Okay, I'm Norman Meyer. I'm the clerk of the bankruptcy court in the federal bankruptcy court in New Mexico, and a lot of this is resonating with me because of our clientele, which is a lot of poorer people who need bankruptcy services, clean the slate in terms of their money stuff. And the research was very interesting for me. That 2 out of the top 4 things were money related on the research. But echoing back on what Amy was talking about, people coming in and then thinking they know what they're doing and then going off on a different path when they get the information. The whole access, to me, you need to flip it on its head. It's not just being able to get to court and then have court services. It's the population at large knowing what their options are before they get to court, and having information out there and education to the public at large. And that's a real challenge we have in the bankruptcy community, because there's a lot of misinformation out there. And so it's a real challenge for me in my court to try to reach out to the population and do it before they even get to us. And I think that's a big piece of the 100%. So that's just more of a comment than a question.
And I just, as Renee makes it to the next person, just want to also add, I think we need to be aware that the consumers, as they educate themselves, they might learn the information, but they generally will often make a bad call about the downstream consequences of the choices they make, because the law is not logical, right? I mean, there are interconnected pieces, and things happen in ways that the layperson might not expect. So as we put our information together and build our systems, I think we need, in a respectful way, to somehow communicate that I've been through about 5,000 divorces, right? You've been through one, or you're in the process. Take some lessons learned here of downstream consequences we should be aware of.
Okay, so I'm from Georgia, right, like Erica. One of the concerns that I have with respect to access to justice falls along the lines of what is and what is not legal advice. And what I often am confronted with, whether it's in our courthouse or in others, is a real lack of understanding by court staff, whether that staff is in a clerk's office or whether that staff is in court administration, as to what's legal advice. And I think that that's a real barrier to access to justice for the litigants, because in many circumstances, at least from what I've seen, the carte blanche way to handle things are, well, that's legal advice, we can't offer it to you. Yeah. And I can appreciate Madam Clerk Woodford there talking about, hey, Dexter, I can't take your ham sandwich, but I can give you this, please complete these forms. And sometimes it is that simple, oftentimes it's not. And I would really like to see clerks of court and other court professionals really hammer out what's legal advice and what's not. I think that's a real barrier to access. And everything doesn't have to run through an attorney. I don't have anything against attorneys. But in some litigants, quite frankly, I see the statistics, some litigants don't want an attorney. But a lot of them, especially in my jurisdiction, cannot afford an attorney, okay? They just don't have the money. And so when confronted with staff, when a a member of the public comes to a courthouse to resolve whatever the issue is and cannot get basic questions answered by court staff who know the answer, and say, well, I can't give legal advice. I think that's a severe impediment to justice, and something needs to be done about it. I don't know what the answer is, but I'd like to hear from you all as to that. What steps what can happen to, sort of remedy?
Thank you. I think I have a colleague here from my county, Sharon, who is an attorney, and we have this dialogue all the time. Opening our self-help center, which Renee talked about at the beginning, she and I worked a lot on that. This was a really big issue. This was an issue that was brought up from our judges that were on the bench, from our bar association, who quite frankly was concerned about court staff giving legal advice or taking away business, and also from our employees. Now, we have a code of conduct, and it clearly says the court employees cannot give legal advice. Having supervised line staff for many years, I have seen it go both ways. I've seen the staff say, that's legal advice, I can't help you. That's legal advice, I can't help you. That's legal advice, I can't help you. And they're not even really listening to the question. So much of what goes on when you talk about access to justice and people's backgrounds and what they're going through and whether they access the court at all, especially in a family division, is about listening to what somebody is saying to you. And if you are constantly interrupting them to tell them that the end of their diatribe is going to be legal advice because you've already predetermined that, you're not listening. And so I've seen it used as quite frankly, an excuse not to help somebody who might be difficult or angry or upset or have an issue that might take more time than maybe we're willing to give them. But I've also seen it on the flip side, where somebody has given the answer because they want to help, and they want to help too much. And so they give an answer, and they're not an attorney, and the answer is wrong. And they go before the judge, and the judge is like, who told you to do this? What are you doing? You've got to go back to the beginning. And that litigant is very upset and then very distrustful of the court system. So I think we need to understand that it is a very delicate balance. But we did do a lot of training around what is legal advice versus what is legal information. What tools do we have available to people online? Our forms, are our forms written in the 4th grade reading level? Are they in a, what forms are more friendly? Are there frequently asked questions, things like that might be, are we giving too much information? Are we giving not enough information? So we did really put a lot of thought into that. We spent a lot of time talking to staff about taking the time to hear what somebody's saying, to repeat back to them. That's the other problem. Court staff is filtering what they're hearing through their legal experience. And so while the person is talking, they're doing this internal decision tree, and they're getting to where they need to go. They're not really listening to what that person's saying. And so repeating back, okay, I'm hearing you say that you are here to file this because you want to do that. Is that correct? When I hear court staff say that, I'd say about half the time the person says, no, that's not what I'm saying. Or yes, that's what I'm saying, but if that's what that means, that's not what I'm here for. And so I think, and reasonable minds, I think, in the field disagree on this, but I think that you can give here is the legal information. This is what it means to come to court. This is what it means to file. What you're telling me you need to do is something that can only be done via a motion. I don't think that that's legal advice. I think that you can give somebody options. Sometimes there's only one option, and yes, that's the answer to the question. But you have to have very, I think, highly trained, compassionate staff who are confident and who feel supported by their management when they might make a wrong call, and they need to be closely supervised. And that I see as a challenge. The previous session I was in yesterday was a lot about court funding and the funding crisis and the legitimacy and all of those things. I think is something we all struggle with.
There was one more question, but I wanted to offer a comment to that. I think what Amy's telling you here, first of all, you should all listen to because it's good personal life advice. But you can use these tools in your real life. But also, I think it changes the landscape of employee in the court. And what she's suggesting to you is that not all of your employees, thank you, John, not all of your employees anymore can be low-level clerical staff. Because these skills that she's suggesting to you are ones that require some cognitive ability, but also compassion is really, really important in this area. And some people have it and some people don't. And it is not a teachable skill. So that's really something to learn about. I mean, I will fully admit, I probably wouldn't get that job. I am not overly compassionate. But now, let me segue into our question.
Well, actually, it's two parts. First of all, I really enjoyed the data piece earlier on, but what I've seen happen in our court is when we try to access some federal funding for our self-help center, it actually changes the mission of the work of the self-help center to stay in line with the federal requirements. So it's really tough to take child support money and plug it into a self-help center that is about custody. So I like the idea, I'd like to work with it, but it's really tough. And that would be my first question is, what am I doing wrong? What is something we could do to be more successful? But then I'll give you my other part of the question is, it piggybacks on what Amy was saying. Amy and I work together quite a bit. First of all, I don't think it's just low-income people who are seeking access to the courts without lawyers. I have a 31-year-old and a 27-year-old, and when they have legal issues, they don't call their mom, they don't call their stepdad, they get on the internet. And they get all of the information they need to take care of what it is that they need to do, and they've been really successful at it. And I think it's a new generation, and as courts, we need to be cognizant of that, because these younger kids who are so savvy and know how to get information are very frustrated when they walk into our courthouse and we can't boot up the computer. And they are our consumers, right? I mean, they really are. But to jump on what Amy was saying, it's first rule is do no harm. And when you set up a self-help center, but you don't have the resources to adequately supervise and train staff, you actually are doing more harm when people come in thinking it's this great tool and they just get frustrated again and maybe get sent somewhere else. So I guess my second question, if you can even remember my first at this point, is what do you see? I mean, what does it take? What kind of funding? What level of people to make this a success? Or do you do it through technology? I'm a big fan of the kiosk.
To answer the second question and also to give a comment on some of the previous statements, I agree wholeheartedly with what Amy was saying. Prior to me taking office, the clerk's office staff, the front counter, which is the front line, was the initial starting point of the staff. So your new hires would go to the front counter, and then the more experience they got, they would move up to civil, criminal, real estate, court management. So whenever there was an opening in the other departments, they would take someone from the front and put a new person at the front. And the minimum requirement is to have a high school diploma. Right? Does anyone have any experience with this? Have any of you seen this? Am I the only one? I know my esteemed colleagues, you haven't experienced this. So what I've done to change that culture is to have the front counter as its own department. So this is a department with a supervisor or lead. We have to have highly qualified people there. And even though the requirement is still a high school education, I haven't changed that in the job description. I find that most people that I hire have some sort of training, either an associate's degree, a bachelor's degree, some master's or graduate type training. And so the front line is now a higher level thinker, if you will, because they've gone to college, they have these analytical skills, they also are compassionate. To answer Edwin's question, to go back to the difference between legal advice and information, legal advice is giving a professional or formal opinion regarding the substance of the law. So you're taking the facts, the law, and you're giving an opinion. Giving information, you're just giving out the facts. In the clerk's office, you can give out the facts. So what's the age, the legal age to do da-da-da-da-da in this court? This is the age. How long do I have to file this or to file a response or an answer? You have 20 days. So we can give out information and facts without that being legal advice. When you start saying, well, I think that you should, when you think, that's a problem. Okay? And how many of you all in the clerk's office, you know that the clerk's office is the first line of defense for anything. Someone called and I happened to be at the front counter, I answered the phone, and the question was about a dog in the yard. There's a strange dog in my yard. Okay, call animal control. You know, we're the first line. Or is it just in Bibb County where you get every type of question? And if you take the attitude, I can't answer that question, you're not helping. Because most people think that the clerk's office is their first place to go, regardless of the question.
Hi, my name is Rich. I'm from Cook County, Illinois. And I just wanted to piggyback and make a comment on what you said. One of the things that I tell my clerks is, as clerks, we're not supposed to think. It's not our job to think, it's to do. And they look at me like I'm crazy because, you know, but there's laws that we're supposed to follow, and as long as we follow those and give the information or procedural information and stay away from opinion, that's fine. But it's when we start to think and use those words like should or could, that's when we start to get into trouble. And one other thing I'd like to add is that you mentioned that either you have it or you don't, but there's also a case where people that have it can tend to lose it over the years. Yes. Once you do this job for 5, 10, 15, 20 years. 5?
Yeah.
Well,
Hopefully it's longer than that.
I'm just saying that you lose it. You get numb to the situation. You forget what it's like to be on the other side of the counter, and you're desensitized to what those people are feeling. And I think that we need to have some empathy and understanding for what they're going through. I try to say, think of what you experience when you go to the DMV or you go to some other office and how they treat you, and think about that when you're trying to do.
I've said that's a real thing. It's called compassion fatigue, and my turnover, I'd say it hits about 2 years. So it's less. It's way less than 5. But along those lines, I always tell my staff. So there's this thing at court. You know, sometimes cases are, you know, roll call. Everybody come at 9:30, or you have a time, but the time slips away. And I always say, I'm that person at my doctor's office where if my appointment's at 9:30, if I'm not called at 9:45, I'm at the window. So I think we do tend to lose sight of this. The other thing to keep in mind is I think no matter who is accessing the court or what kind of court it is, a family court, a civil court, a criminal court, a municipal court, something has happened to that person. They are feeling that they need to come to the court to have the court resolve that. They are defending against that. They are a witness. They have been subpoenaed, whatever that might be. And I'll just tell you briefly, it was a real eye-opener for me. I had a woman call me, and she was asking me all these questions about her case. And it was a custody case. And I pulled up her docket, and I said, am I missing something? Because there's nothing that's been filed here recently. The most recent thing that I see filed was 2 years ago. Am I looking at the wrong thing? Has something not been filed? Is something misfiled? And she said no. Now, this was a woman who was actually a therapist at our Western Psych Institute here as part of UPMC. She had been married for 20 years. She had 2 children and had gone through, starting 5 years prior to the phone call, a very contentious divorce with domestic violence, and it had been before the court many times, and there had been a custody trial, 3-day custody trial with a decision. And so the last thing I was looking at was that judge's order. And she's asking me all of these questions. Well, why did this happen? Well, what happened here? And why did it happen like that? And what was the result of that? And she said to me, now this is a woman that we think has all of the tools available to her. She said to me, it's just now 2 years later that I feel like I'm out of the fog of that, and that I'm starting to really process what happened to me and my family, and now I have some questions. So that's the other thing. People coming to us are often in a fog, and that may mean, yes, you need to slow down. You need to say the same thing 10 times in a row without getting frustrated and mean. And you need to be able to do that. And you need to check for understanding, because you need to have that empathy, because you're not helping them otherwise. And I think that that's something that's really important for us to keep in mind.
We have one more comment, or 2 more comments. I'm going to go here first. So it's a new voice. Let's hear a new voice.
And while Renee's walking, I just want to answer the question about, I think, 4D that you were asking, the impact of that. Of course, it is a balance of when you do get external funding, does that start driving what you're doing? And I think there's a few ways to look at it. One is if you can get adequate funding for, let's say we're working just in child support on 4D, we test a whole bunch of mechanisms and approaches that can then later be used in other case types and other situations. We develop materials, we learn how to change our staffing, our supervision. I think your point about supervision is critical. And then the ongoing training and all of that. And then you can hopefully be able to make your case to expand that through other parts of the operations. And in California is sort of like one of the poster children for this example, where they started with the facilitators program and child support, and then ultimately got legislative support for self-help centers in every county that were broader. But using, just going kind of full bore of, wow, we are really going to figure this out through that funding for, maybe it's just limited cases, because you have to have the 4D reimbursables. But that can end up creating the infrastructure that carries you through other case types. So I just wanted to make sure that didn't get lost. Sorry.
Hi, I'm Sandy McCurdy. I'm the clerk of the court in Johnson County, Kansas, which is metropolitan area. It's the largest county in Kansas, Johnson. We started a self-help center on our own. We went to New York to kind of visit them to see what it was all about. Came back and set up our own. We have no funding from anyone. I carved the staff out of my office. They are higher paid staff. We found that we needed that type of person. It was really difficult to go from regular clerk work like we were used to this self-help mode. It took a lot of training, a lot of, okay, it's okay to tell them that, it's okay to do this. One thing we do a little bit differently, we have forms online, but they can also come into our office. We set up a separate space for them. Come into the office, and we have about 6 computers set up around the room that they can go to and fill the forms out while they're there. And we can go ahead and file everything and take care of all the paperwork and everything. Another thing we do a little differently with the attorney piece, Kansas Legal Services and a couple of other pro bono type organizations have attorneys that come in on a regular basis, and we can set people up with appointments and attorneys at the self-help center for that kind of help. We've also taken a little bit of the load off of some of the judges that are assigned to these cases. If you have a divorce that comes in that's really quick, no problems, just simple, cut and dry, we have a night court set up that they can come to night court and don't have to worry about taken off work and everything. So we've expanded that to that.
Thank you. So I saw 2 other hands, and this is a really great discussion, and I've been hesitant, as you can probably tell, to cut it off because we only have 15 minutes left. And I promised you all of this media, and I'm so excited about it. So I wanted to transition a second, and I think you've all given me some great segues to this different media opportunities we have in the presentation style we're using. So one of the things we've been talking about here is communication and how are we communicating to the public. And so I'm going to skip ahead in the presentation so it'll be very exciting to you because you'll see all the things that we probably aren't going to get an opportunity to talk about. So think about them and ask us about them later. And but I really want to show you a couple of the things that we've prepared. And Catherine's been teasing it, and some of you have mentioned it as well. So while I was preparing this presentation, I really literally spent an entire evening on YouTube and Imager and Reddit trying to find really fun and interesting stuff to show you all, to give examples of what we're talking about. And I found this really great YouTube video of an actual litigant who had just went to court, and he had just accomplished what he had hoped to accomplish, and he needed to tell the world how to do it. And so he videoed himself and posted it on YouTube. So I put that in the presentation. And then when I checked all the YouTube videos in the presentation last week, YouTube had removed it. And it was a Latuda ad. So I couldn't show you that, but I wanted to tell you about it because what we decided to do instead was a little experiment while we're here. So I want to talk to you a little bit about communication, and part of the collaborative partnership is how are we communicating to the public that these services exist, and this really goes to Rebecca's work too. How are we communicating with the public about how to resolve issues, whether the public believes it's a legal issue or not? And so is that the responsibility of the community, or is that the responsibility of the court? But I think the message, the takeaway here will be, we have to make that decision, and we have to do it, because if we don't do it, the public will do it themselves. And I wish you could have seen this guy. It was great. He was good. But first, let me show you an example of a court who has taken on the communication task themselves. Whether they collaborated with their community, I couldn't speak to. And again, I just pulled this off of YouTube, so don't tell them I'm using it. It's not very exciting, is it? Oh, no. No, it's not, though. We tested the volume. Oh, it is. Thank you.
This class about how to co-parent your children.
Thank you.
And how to make sure that your children are protected from whatever issues and disagreements brought you to this point. These topics are very important, and I hope you listen to what's said here today and learn from it. One of the reasons family court cases are so hard for judges is that we see firsthand what happens to children when parents refuse to co-parent effectively by arguing in front of the children, or talking badly about the other parent in front of the children, or expecting the children to pick sides or choose one parent over the other. I'm not here to talk to you about co-parenting. What I want to talk to you about is the family court process and how your case will proceed through the Maricopa County Family Court. What hearings might occur in your case, what might happen at those hearings, the issues in your case that either you or the court will have to decide, and what the law is in Arizona on those issues. Now, some of you may be here because a petition for legal separation was filed. Those cases are rare, but the process in those cases is very similar to what happens in a divorce case. So if you are here in a separation case, pay close attention to what's said about the divorce cases, because that information will apply in your case as well. We're going to cover a lot of information here today, so before you leave here, you will be given a handout which goes over what's said. That way you will have all of this information in written form. Make sure you keep this handout so that you can refer back to it during your case.
There was introducing music. Okay, so that's one example of a court who kind of took the bull by the horns and decided they needed to inform litigants about what they should expect when they go through the court process. So what I'm going to do now is kind of an experiment that we decided we would do just this morning using what Catherine suggested earlier, the internet. And so first what you see when you just Google, how do I get custody of my children, are a lot of the, AVO and legal services. You also get a wiki page, which I thought was really interesting. Lots of lawyers. That's not what your clients are looking for, but you do get some court pages. Congratulations to those courts that got up there on the first couple hits. I thought the wiki pages were interesting, though. So we all know that we know Wikipedia. Who doesn't know Wikipedia? Don't raise your hand. The point of the wiki is to allow people to upload their own information. So you can go and change the definition of anything on there. Now, as a society, we can also pull that definition down if we think it's incorrect, but it's up there. So these are individuals, and some of them, I did look at them, you can see by the purple, that some of them really are lawyers who are giving legal advice on the wiki, but some of them are the public putting up their own personal experience about how to get custody of your children. So not quite as powerful, I think, as the YouTube video. I wish it wasn't a Latuda ad anymore, but it is, so we can't do that. And then we have just a couple minutes, and so I'd like to just go to one last thing, which was the discussion of funding. And I wanted to kind of show you what I found about funding in how Canada is proposing to have 100% access to justice.
If you broke your arm, you'd probably go.
I wanted this to queue up to be a little bit later than 13 minutes of this guy, but let's start here.
And so the next time that you feel hard done by, or cheated, or frustrated, take note of that feeling. If it's happened to you, it'll happen to somebody else. And the next time that you see a friend or family member struggling with an injustice, take notice of that. And then demand change. Just as we need to change attitudes within the legal profession, we also need to change attitudes in society more generally. It's time to tear down the walls between the legal profession and the public. We need to dismantle the idea of law as an inaccessible castle. How do we do this? Well, there are many possible ways. But how about this? What about universal legal coverage, similar to universal health care? When I ask you the first questions today, what would you do if you broke your arm or had a persistent cough? You all had an answer. But 100 years ago, before health care became part of the fabric of Canadian society, the answers wouldn't have been that obvious. Today, we have a health system that, according to a survey done in 2012, is a point of pride for more than 90% of Canadians. And people across the country use it every day. Isn't justice worth a similar commitment? And if we know that everybody is likely to have a legal problem at some point in their lives, but that they're also not going to anticipate those problems, shouldn't we do something to help them protect themselves? Here's what it could look like. You could pay into a system, either voluntarily or through your taxes, that would provide free or low-cost legal counseling if and when you need it, and also provide high-quality legal representation if you need that to defend a lawsuit or change your will or fight an eviction. Now, if you think that this is far-fetched, remember that many countries encourage people to save for retirement through special features of their tax code. that have special provisions for retirement investments. And here in Canada and many other countries, the health system is funded in whole or in part through your taxes. And since your taxes already pay for courts, shouldn't they pay for your ability to be able to access the legal system when you need it? Now, I don't have all the answers, but my point is this. Having a serious conversation about legal services for everyone is worthwhile. Right now, it's not part of the public debate. But with the change in attitudes, that could change. The idea of a truly accessible justice system is something that's so far away that most of us haven't given it any thought. But everyday justice affects us all. And I believe that it is possible to get there from here. Thank you very much.
So just a thought on funding. Revolutionary, I know. That was actually recorded in the early 2000s, so they're obviously thinking about it in Canada, so they might be a little ahead of the curve. We are actually a little bit out of time here, but if you have any final questions, I mean, we'd love to hear from you. Feel free to come up to the podium. Thank you.